Hello there. I am a plaintiff's lawyer. I will come to your business and I will check it to see if you have followed Alan's advice. Someone may slip and fall and you may not have enough insurance. Or fluorescent light bulbs may cause damage to the skin of your employees or customers. Or you may have improvements to your building that were not permitted or covered by insurance. I hope one of these things has happened so that I can make my fee. I used to work for the IRS, but the benefits were not as good. Anyway, this is the introduction to the program called, let me read it. Planning with and for the family business, part 2. Do you people not have anything better to do than to watch this? Apparently not. Well, here it goes. And thank you very much for attending. Please do not make a lot of noise during the presentation because you will interrupt your neighbors who are also pretending to attend. Thank you. Okay, it doesn't get any better than that, does it? This is Alan Gassman, and we're here to talk about planning with and for the family business. This is part 2. You can go to the YouTube channel if you search Gassman, Gassman, business law or something like that. I'm sure it'll come up, or Alan Gassman YouTube, and you can see part 1, which was probably better than part 2. I welcome your questions. You can go to the question panel. You can click on the upside down questions thing there, and then you can type in a question like, when will this finally be over? Please note that this presentation does not qualify for continuing education because it isn't good enough and because we didn't have time to qualify it. It's a lot of paperwork. There's the YouTube channel if you want to go see it. I'm always plugging our EstateView software, so consider this a plug for EstateView software. At the end of the presentation, I'll probably spend 5 minutes or maybe less talking about EstateView. If you buy EstateView today, then you can get a 10% discount, but don't tell anybody. You would put estateview.link in your browser, use the promotional code 10PERCENT in all caps, and improve your life dramatically. The most popular version is the $4.99. If you're watching this on YouTube, send us an email and you can get a smaller discount. Today you'll get a 10% discount. So we talked last time about the importance of setting goals and getting a competent team of advisors. I can't overemphasize that. If you don't have a good lawyer, a good CPA, a good insurance person, a good financial advisor, then you have a high risk of something going awry. And I'm not talking about rye bread. We talked about asset protection being an important motivator. Don't forget that. There's always somebody out there getting ready to come and take all your assets. And that's an important reason to use multiple organizations and friendly debt, which we will be discussing. We did not get to confidentiality planning or estate tax planning very much, and we'll get to that today. And I don't want to forget to mention the importance of compliance with the Corporate Transparency Act. Your deadline for complying with that is January 1, 2025. So we've just got till December 31st to give the Treasury Department copies of your articles of organization, copies of the driver's license of each person who has control or more than 25% direct or indirect ownership, $600 a day penalty beginning January 1st of next year if you're not registered. So, you know, how much more fun could there be? We talked about different asset protection definitions. You can go through and read these. I didn't cover all of them by any means. And let's start off on page 46. And Aldo, I apologize, I don't know the name of my YouTube channel, but we'll find it at the end here. And if you just search Alan, A-L-A-N, Gassman, G-A-S-S-M-A-N, YouTube, Y-O-U-T-U-B-E, there's lots of puppets everywhere. So here is a single individual, no longer married. And what may this person own? Well, there's an IRA, there's a 401k. In most states, those are absolutely protected from creditors, including in Florida. And then there may be a car, and cars are not protected from creditors. Many clients choose to borrow money to buy a car or to lease a car so that there's very little equity there for a creditor. The more important thing is please, please, please don't let anyone drive your car but you. Because if somebody else drives your car, you may be responsible for the accident. When we get a client, we run a public record search, especially if the person is an individual. See that? This person is an individual. We got to change the spelling there later. But if that individual has a car used by the son-in-law who gets in a terrible accident, then the individual owner will be responsible. Now, in Florida, we have a statute that says your liability is limited to $500,000. And if the driver and the car have $500,000 of coverage, you should be fine, right? And the answer is wrong. Because if you were negligent in entrusting your son-in-law to drive your car, because you should have known he texts and drives and is a terrible driver and is night blind and can't see in the rain and always plays really loud music, well, then the statute does not limit liability to $500,000. When you have a married couple, that's the symbol for married couple, like handcuffs or together, something like that. When you have a married couple and they own a car together, if Marcia and I were to own a car together, which we don't, if I get in an accident, is her liability limited to $500,000? And the answer is we don't know because the statute is not perfectly drafted. So these cars, jet skis, golf carts, just use Uber. Tell your kids to use Uber, tell your spouse to use Uber, and tell your employees to use Uber. You know, it used to be, oh, I'll have my employee run to the restaurant, get the food, bring it back. Well, now Uber will do that, or I'll hire a delivery service to do that. There's even delivery notaries now, by the way, which is a wonderful, wonderful service. And there's delivery phlebotomists, so I don't have to go to the blood lab or the doctor to give blood anymore. They come to your door. So that's all good stuff. Next, annuity contracts. So I can call a low-cost annuity contract provider like Fidelity, and they only charge 0.25% a year to wrap my mutual funds in an annuity, which is creditor proof under the laws of many states, including Florida, Texas, and New York, not California, I don't think. But when I pull the money out of that annuity, it's ordinary income. They may have permanent life insurance as creditor proof. And then in Florida and Texas and many other states, your homestead is creditor proof to unlimited value if you meet certain guidelines. Then there's a revocable trust. Oops, not creditor protected at all. just avoids probate, avoids guardianship. That's noble, that's good, but it does not protect from creditors. And unfortunately, many people think that they do. So an irrevocable trust for descendants, whether you love them or not, you may want to set up an irrevocable trust for your descendants. And then if it owns 3% of your building LLC and your living trust owns 97%, and someone gets a judgment against your living trust, they're not able to reach into that LLC if the law that applies says that the only remedy of a judgment creditor is what's called a charging order. It has nothing to do with electricity. It has everything to do with only thing the creditor can get is a lien against your future distributions. Now, if you live in Florida or Iowa or one of the other charging order states, such as Delaware, Wyoming, Texas, then the sole remedy of a judgment creditor of an LLC in your state is the charging order. But if you live in California or New York, the sole remedy is not the charging order. What if you live in California, but your LLC is set up in Florida, Wyoming, or Delaware? Do you have charging order protection? The answer is we don't know, because the case law hasn't finally determined that. The Iowa Supreme Court in the Ratterith case said that a Floridian's LLC is controlled under Iowa law and that Iowa charging order law applied. But there was a recent case in New York where a New York court said that New York law and not Delaware would apply. But it's better to use a state to form your LLC in that has charging order protection in case the courts go that way, or some clients go as far as having us set up an offshore LLC where there's going to be charging order if there's a court that goes to that entity. So if I set up a Nevis LLC and my assets are offshore, you're going to have to go to a Nevis court to try to enforce your judgment. And Nevis is going to say, sorry, charging order law applies. We don't have the full faith and credit clause of the US Constitution the way that we would have in a state. So this person may want to have charging order protection and not much more, or may want to use an offshore or US-based asset protection trust. And I don't think you really joined me here today to hear too much more about creditor protection. If you want to hear more about creditor protection, please let me know. And you can go to our website. I'm sorry, not our website, our YouTube channel, or you could even buy our books on Amazon. And if you buy 1 million of those books, then I will be able to take 2 weeks off. All right. I do want to do a polling question, but you do not have to answer this. If you do want to answer it, though, it helps me know who I'm talking to. So I'm going to hit launch here and hope that I get this right. Wow, I think I got it right. Are you a CPA, a lawyer, a financial consultant, none of the above, or my favorite character, Yossarian from Catch-22? And once I have that answer, we have 66% of you have voted. That's almost 2/3. And thank you very much. You are 44% CPAs, 20% lawyers, 17% financial consultants, and 15% of you, the lucky few, are none of the above. I will close this poll, and thanks for letting me know. So I'll be talking tax talk a little bit, since 64% of you, actually 81% of you are financial professionals, but a lot of you also have your own business. So one thing I like to talk to clients about is confidentiality planning. even though the US Treasury Department knows who owns your company, not like the 300 employees there are going to be able to do much with the information. Do you want the general public to know who owns your company? And if it's a Florida company, all you have to do is Google the word Sunbiz, Sunbiz, and the person's name or the company's name, and snap of two fingers, it takes two fingers, I think, last time I heard, you instantly know who the manager is of anyone's company, and it's required under Florida law to report the manager. You do not have to report the owner, you just have to report the manager. Some people are managers and members and they report themselves, but you don't have to. Nevertheless, a lot of clients just have us open a Wyoming LLC called Quittle Bittle Management LLC, and we make that the manager so that the Florida website doesn't show. Now, the Florida website also has to show the address. What address are you going to use? That's another question. And you're supposed to use a Florida address. So more of our clients form Wyoming LLCs than Florida LLCs. Why Wyoming? Number one, it sounds really cool to say, why Wyoming? Secondly, Wyoming has charging order protection. Wyoming has tenancy by the entireties, just like Florida. Wyoming is less expensive than Florida. And when you go to the Wyoming Secretary of State and you want information, you just don't get it. On their website, it shows the name of the company. It may show the registered agent who's not going to tell anyone anything. And then it doesn't even show the manager. Wyoming doesn't want to know who the manager is. Delaware, you have the same advantages, but Delaware is more expensive. And did you know that when you terminate a Delaware LLC, it costs hundreds of dollars, and if you don't terminate it, unlike the other states where they go, okay, no problem, you're shut down, bye-bye, Delaware says, it's a problem, you haven't paid us, and they send your company and the people involved, the officers and directors, for collection. And they've done their and then they sue them. They probably sue them. So although Washington did cross the Delaware to save our country, he did not form an LLC there because he did not want to pay the termination fee when he went to close down the LLC. That was found in Martha Washington's papers in the Smithsonian Institute shortly before she invented the internet, just so you know. Okay, so let's talk about confidentiality for a business. And I have here two slides because this thing really was hard to see on one slide. But just to give you the lay of the land, on the left, I've got a person's Wyoming LLC owning a homestead under a land trust. Then I've got a Nevada Asset Protection Trust owning a Delaware holding company owning Wyoming LLCs that own properties. And then I have an S corporation structure. So there's really something for everyone here. And I even have an irrevocable confidentiality trust that I hope you'll enjoy. So the next slide is the left-hand side, and the following side is the right-hand side. All right, so here's the left-hand side of my chart. This person has a homestead in Florida. Maybe it's in the town of Homestead, Florida. So they don't want their personal information on the property appraiser website. Nothing personal, they just prefer not to have people be able to go to the website and search their name or their address, find out how much they paid for their home and that they live there. So we set up a land trust, which is owned by the client. The client could be an individual or a married couple. If it's a married couple, we carefully draft them land trust, if it's Florida, to make it a tenancy by the entireties land trust. It owns the home. The trustee of the land trust is a Wyoming LLC. And now the property appraiser website shows the owner a Wyoming LLC. You can't go to Wyoming to see who the manager is necessarily. And it owns the homestead. Now, the property appraiser needs the individual information to give the state income, the property tax homestead exemption advantages, which includes a 3% cap, plus about $1,000 of savings beyond the 3% cap. So they are willing to put the name of the Wyoming LLC and not the client's name on the website. Now, I think it's Palm Beach County, they insist that the name of the owner be on the website, but we were able to convince them to have the name of the owner be Alan Gassman as agent under durable power of attorney for Mary Smith, but they only show 32 characters. So it says Alan Gassman as age, AGE. I'm 65, by the way. So some people must think that I own that home and that my third name is age. But anyway, that's the confidentiality of a homestead, and it works similarly in many different states. The next thing is real estate deals. Now, maybe this client lives in Wyoming, or maybe this client lives in a state where the real estate they own is not active enough to be considered to be an active business that would have to register. So in other words, this could be a client who has 4 properties in Florida. One is triple net leased to his business. One is vacant. One his daughter and son-in-law live in, and he at least loves the daughter. And then the 4th one may be a property that he's building, but it's not actively leased yet. So we can use Wyoming LLCs, and then we could use a holding company. Why Delaware? I don't know. It looked good on the chart. Maybe multiple entities is a good idea, or maybe he already had a Delaware holding company. Now, these properties are free and clear, so we put some debt on them. Each of these LLCs owes the Delaware holding company about 70 to 80% of the value of the property. So this property is worth $1 million. This LLC, which owns the property, owes a $750,000 promissory note to the holding company. Why? Has nothing to do with the fact that Y begins with Wyoming. The why is somebody goes and trips and falls and sues the landlord. The landlord is the LLC. The landlord gets a $10 million judgment against it. It files bankruptcy. It sells the property, and the first $750,000 goes to the Delaware holding company. There's either a mortgage on the property, which is safest, or the promissory note says that the lender, the Delaware holding company, has the right to require a mortgage or lien upon 60 days notice. That mortgage is put into place more than a year before the jury trial. So when a plaintiff comes and looks at this and says, oh, $1 million shopping center, can I please have a check for $1 million? No, how about 250? And how about let's go to a jury trial in 2 or 3 years and see if you get anything. So it's much more likely that the plaintiff will settle for the limits of liability on their policy. Nobody knows who owns these entities by looking in the public records, and you do not make the Delaware holding company the manager of these LLCs, because when somebody gets hurt, they're going to sue the manager. So the manager is going to be that nice person who actually manages the properties, or maybe another entity that can be the manager. You could creatively call it Management Company to Manage Wyoming LLC, and that name may be available. By the way, when you form these entities and you want to get a tax ID number, you normally go to the Secretary of State and you say, is this name available? And you find out on the website it is. You form the number, then you go to get your instant tax ID number with the IRS, and they say, no way, sorry, but this name is already being used with an ID number in somewhere else, so we can't give you one. Mail us an application and we'll give you a number in a few months. So there is a website, I forget the name of it, but if you email me, I'll be glad to send it to you. And the website checks for name availability in all 50 states simultaneously. So that's useful when you want to get tax ID numbers. Each of these 4 subsidiary LLCs can have a separate tax ID number, preferably a separate bank account, or if you want to be a little bit at risk but simpler, one of them could be the management company for all 4, or you could do a 5th company that would be the management company, enter into management agreements, etc., etc., take an etc. in. But we're trying to limit liability here. Okay. Now, the ownership of the Delaware company. It could be 97% under a Nevada Asset Protection Trust. What is a Nevada Asset Protection Trust? It's a trust with a Nevada trustee. Nevada law, Delaware law, Alaska law, South Dakota law says you can set up a trust for yourself, name a trustee as trustee or co-trustee in our beautiful state, and your creditors won't be able to reach into the trust. Now, we're not absolutely sure if that works or not. If you have a Florida person with a Nevada trust and a Florida creditor in this situation, but I can tell you from experience, the creditors are more likely to settle, especially if the Nevada trust says that the alternate trustee is in Nevis or the Cook Islands, and the plaintiff lawyer sees that when the Nevada trustee resigns, this thing's going offshore. So that can't hurt. This trust would be disregarded for federal income tax purposes. And if you went to visit your trust company in Nevada and you happen to go to a concert on a weekend to see the Eagles at the Sphere, I sure wouldn't miss that opportunity to talk to a trust company in Nevada and see the Eagles. I think right now the Jerry Garcia Dead band is playing at the Sphere. And if you haven't heard about the Sphere, then just forget about this webinar. Go read about it. I went and it was just amazing. All right. Sorry for the little cough that I have here. I'll hit mute. I'll hit mute and I'll cough. And I'm back. All right. So next thing, there's an S corporation. Now, most small business companies are owned as S corporations as opposed to partnerships, because if the owners work in the company, they have to take out a reasonable salary, but everything above that can come to them as profits, not subject to employment taxes or the 3.8% Medicare tax. So most clients have an S corporation or multiple S corporations, and those S corporations have lots of really nice activities and lots of really nice assets. So what we like to do there is we like to separate the S corporation into separate entities. But if you pull appreciated assets out of an S corporation, you trigger income tax as if those assets were sold. What you can do instead is what we call, and we've written about this, you can Google Gassman new parent, F as in Frank, reorganization. So what I did was I had a S corp that had a professional practice of some sort, and it also had a building and equipment. So what do? We set up a new parent company. We transfer the ownership of the S corp to the new parent company. The new parent company makes what's called an S election, and the subsidiary company makes what's called a Q sub. Makes you want a sandwich, doesn't it? A Q sub, SUB election, qualified subchapter S subsidiary. I think it's a form 8369. Don't forget to file it. And now the tax ID number of the subsidiary entity continues to be used, and the subsidiary entity can now transfer its assets to other subsidiaries of the S Corp, which can own the equipment and lease it back at an arm's length lease, can own the real estate, lease it back in an arm's length lease. Now the plaintiff lawyer sues the business activity and can't get the other assets. And for a lot of clients nowadays, the biggest asset is intellectual property. It's my website, my unique name, my formula for making this product. So we set up another entity for an intellectual property company, which may own patents, may own goodwill, may own trade knowledge, and then may charge a royalty. I'll be talking more about the new parent F reorganization, give you a reason to live, but that's a nice thing. Now, this may be interesting for the tax advisors out there. There's another entity choice called a C corporation. And a C corporation is taxed at the 21% bracket plus state income tax, Florida 5.5%, but deductible against the federal. And with a C corporation, if it's small and you do it right, you can qualify for small business status under Internal Revenue Code section 1202. And then if you sell the stock later on, you may not have to pay income tax on the sale of the stock. So many clients say, I heard that I want a 1202 company. I don't want an S Corp because I'm going to go sell this stock for $1 zillion and I don't want to pay income tax. So do I do an S Corp where I will have better tax treatment each year? Or do I do a C Corp where I'll pay double tax on the money I take out, but when I sell it, I will have no tax or a lower tax bracket, depending on what the tax law happens to be in my year of sale? The answer may be some of both. What if you put the widget factory itself under the 1202 company, but you set up a management company that owns the intellectual property rights under a S Corp structure? The S Corp provides management, the S Corp provides intellectual property rights, the S Corp may provide products. So you have some of your business under the S Corp and some of the business under the 1202 company. Now, when you go to sell, if the buyer will buy stock, you allocate as much as you can to the 1202 widget factory. If the buyer wants to buy assets, you allocate as much as you can to the S Corp. So that way, especially if you're a landscaper, you can hedge your bets. You get it? Landscaper hedges for bets. I thought that was funny. All right. The last thing I have on this confidentiality logistical planning chart is the use of an irrevocable trust to own a business or investment operation. Let's say that I want to put a rental property into place. It's going to be managed by my nephew, and I don't want to set up a company. I don't want to set up an LLC. There's a few reasons I may not want to set up an LLC. One, I may not want to comply with the Corporate Transparency Act. Two, I may not want to trigger the Florida loss of the 10% cap if you transfer property to a company in Florida. The fact that the property appraiser can't raise your tax assessed value by more than 10% a year goes away. You lose your cap. And for some people who have been fortunate with property values, that could be an expensive situation. Well, you may not lose your 10% cap, and you don't have to form an LLC if you transfer your rental property to an irrevocable trust where you are the lifetime beneficiary and you can appoint where the remainder interest goes. Yet under the Florida Trust Code, which is derived from Section 505 of the Uniform Trust Code, creditors may not be able to reach into that trust. So depending upon your situation, there's also, if you may want to consider using a Delaware business trust or a Delaware real estate trust. All interesting stuff. So a simple limited liability trust would be that I form a trust for my wife Marcia and our children, and I put my office building into that trust. And it's an irrevocable trust. I'm not a beneficiary of it. My law firm pays rent. The trust is disregarded for income tax purposes, so the rent goes on my personal tax return. I get the depreciation deduction. Because I'm not a beneficiary of the trust, my creditors can't reach it, and therefore it's a creditor protection trust. Because Marcia did not fund the trust, and because she cannot receive more than she needs for health, education, maintenance, and support, her creditors can't reach it either. Now, I really like my father-in-law. He's a great guy. How about if I make him a discretionary beneficiary of the trust and give him the power to direct assets to creditors of his estate when he dies, but only with the approval of my best friend? Under Internal Revenue Code Section 1041 and the Treasury regulations, that would cause my building to be considered as owned by my father-in-law in the event of his death. Meaning that in the event of his death, my building would get a new fair market value income tax basis, which I could start taking depreciation all over again at the present value of that building. That gives me a great business reason to set up this trust. An alternative is that I could make, if this trust owned a condo or a house that my daughter was going to move into that I wanted to buy for her, I could give her the right to all income from the trust. And under Internal Revenue Code Section 678, she would be considered the owner. And then when the property got sold, if it was her primary residence, we could use the $250,000 or $500,000 estate tax exemption. It's confidential who owns it because the trustee of the trust could be a Wyoming LLC, and it accomplishes asset protection. And because my spouse is a beneficiary of it, we call it a spousal limited access trust. It has nothing to do with the limitations of your spouse. And don't even tell your spouse that I said your spouse may have limitations. It's a spousal limited access trust. And we can talk more about them later, but let's cover a little bit more ground. This is very common. A spouse or a person owns a rental house. Two problems: no confidentiality and unlimited liability. Okay, put it in an LLC and then have a different manager to distance yourself for liability purposes, insulate yourself from liability, maybe have the LLC owe a note to you. But can you get liability and casualty insurance? Some carriers don't want to cover companies because the actuaries don't understand or think that there's a higher risk when a property is owned by a company. Well, this is silly, but practical. Say to the insurance agency or carrier, what if the property is in a revocable trust? They say, fine, we'll insure it under a revocable trust. Well, what if the revocable trust is owned by an LLC? And some of the carriers say, that's okay. We don't look through that. Our actuaries aren't that smart. So this model sometimes is what we end up doing. Now, under the Florida statutes, a revocable land trust blocks the liability, but I don't believe it, because the Florida case law says that if I have a revocable trust which owns an asset, that doesn't block liability. And a land trust is a revocable trust. So even though the statute in Florida may be read to say it blocks liability, I'm not sure it blocks liability. Now, as advisors, you guys know, and a lot of you, I see your names, you've been around a while, you know a lot of stuff, more than me, by the way, but you know that clients come to you and said, I want to set up a land trust because I won't have to pay taxes, and I live in New York, and if I set up a Nevada land trust, I won't have to pay New York taxes, and I'll be able to sell it and not pay taxes. And you go, hold on, this is go to jail stuff. This doesn't work. Land trusts are good for confidentiality, not so good for anything else. That's what we know. All right. Now, want to talk a little bit. Any questions here? All right, from Jim. Is an LLC electing to be taxed as a C Corp eligible for Section 1202 treatment? The answer is yes, if it meets the other requirements. And then you say, where can I find the requirements for 1202 qualification? And the answer is Internal Revenue Code Section 1202. Also, if you email me, send me your 199A book. I'll send you our now a little bit outdated Section 199A book, which has a chapter on Section 1202. So the next thing I wanted to cover here is the BEA, which is the shorthand for what are we going to do before 2026. And the answer is, first, everybody's going to hide under their desk and see what happens in this election. And if there is a Republican sweep, it seems most likely that the federal estate tax exemption, which is presently $13,620,000 a person, is going to continue. Somehow the president, which would be Trump, and the House and the Senate will find a way to have that exemption not go to half in 2026 as it is scheduled to do. On the other hand, if there is a Democratic sweep, given that the Biden playbook has been to reduce that exemption from 13,610,000 to 3,005,000, and given that the law says that it will go to half of what it would otherwise be January 1, 2026, which will probably be about $7 million with inflation. You're going to be busy, if you're an advisor, talking to clients about what do I do to make sure that I make that $7 million gift before 2026. And you say, what $7 million gift? And they say, I heard that I'm going to lose my exemption. It's going to go to half by 2026. So I want to go ahead and make my $7 million gift. And then in 2026, I'll still have $7 million left. And you have to say, no, sorry, it doesn't work that way. If you make a $7 million gift in 2025, your exemption in 2026 is going to be zero. And they're going to say, well, what about the other 7 million? You lost it. It's use it or lose it. Remember the old saying, use it or lose it? So what you have here in this chart is you have a $7 million core exemption. You have a $7 million temporary exclusion. Sorry, it's exclusion. So if those are the two things you have, you've got to give away $14 million, maybe to an asset protection trust where you might be able to get some of it back if you need it. but you've got to give the whole 14. Now, if you give 8, at least you used your temporary and 1,000,000 of your core. And I'll show you after the hour's over a little bit of a state view of how those numbers may work on that large gift, in case you pretend to be interested. Now, if you're a widow or widower, then if you have a extra allowance from your spouse, like your spouse died and left you a 2 million estate to the kids and had a 10 million exclusion. So now your exclusion's 23 million. So in order to use all of your 7 million core, you've got to gift 23 million. So just so you know, that's what's going on. And there's a big reason to get moving on this in 2024. And the reason is that I'm just not that busy this year. So if you could call me after election, we can get on it. But the second reason, the real reason, is that you've got something called the step transaction doctrine. And let's say Marcia has 10 million and I have 10 million. She wants to give me 4 million so I can put 14 million into a slat. Well, what about the step transaction doctrine? What if she gave me 4 million this year and next year I put it in the slat? Well, guess what, friends and neighbors? That probably won't work either, but it'll look better. Maybe I'll need to buy 4 million worth of assets from her for a promissory note. So all those things need to be considered. And thank you for that. And Jim, I will be glad to send you our 199A book. It'll probably go out Monday. Brittany took the day off. Can you believe that? She didn't want to work on the Saturday. So anyway, that's the step transaction doctrine. Now, please consider attending the United Jewish Appeal New York Cyber webinar. Marty Shinkman is handling it this year. Sidcast, we miss very much. But Marty and I are going to be talking about Corporate Transparency Act for an hour and also the step transaction doctrine for an hour. So if you're interested in attending, please let us know. So a little bit more about estate tax, because that's what page 64 says. The applicable federal rate right now is a little bit under 4.5%. We'll look at it after the hour. But what's more important than using that 7 million exemption for a lot of large clients is do an installment sale. So if I could put $2 million into a slat and then sell it $20 million worth of assets for a $20 million note bearing interest at 4.56%, and the 20 million worth of assets earn income and growth at, say, 7.5%, that 3% delta, especially if it's river property, get it, delta, river, or an airline, could be an airline, that 3% delta makes a huge difference over time, completely belittling what you'll accomplish by saving that $7 million exemption. And I'll show you that on the hour. And if you have to leave, and the hour is only in 12 minutes, which is half I think probably a third, 3/10 of a billable hour for most of you. But if you have to leave, we'll be sending the video of this presentation later on today or Monday, since Brittany is not working today. Did I mention that? All right. So then there's this is from the Estate View software. I'm not going to get into that so much right now, but if you want to read how the estate tax works, if you want a little refresher, and if you want to see how we took some people's numbers and put them into Estate View to get the results of their step-by-step planning, including the installment sale, which you can really see the estate tax come down to zero because they're paying the income tax on behalf of this installment trust. So it gets bigger, bigger, and bigger and their estate gets smaller. They even run out of their investments there. You could overdo it. Okay, so I'll make mention, and we can get into this deeper next Saturday, that if you have a really large estate, you'll take the family business. You'll keep the controlling 1% voting member interest, and then you'll do an installment sale to a spousal limited access trust. So I gave my example. Senior family member will make a seed capital gift of $2 million to a spousal limited access trust, take back a $20 million note, and determine what $20 million worth of the family business is. Now, $20 million of the family business may be all 99% of it for most of our clients. But when you have the client that has the $200 million family business, now that's only going to be a 10% sale, or maybe a 13% sale after discounts. So you say, well, let's do a $100 million note. I'll put $10 million into the slat as a gift, and I will take back a $100 million note. And of course, that we're taking a discount for lack of marketability, lack of control. The IRS may come in and say that you just made a $200 million transfer, not a $100 million transfer. Please give us a gift tax based upon a $97 million excess gift. So that's where you say, you know, let's do a $3 million gift, do a $30 million note. They may say that that's a large gift, but I've still got enough exemption to handle it. And let's take the rest of that stock and put it into one or more grantor retained annuity trusts. So next week, I can get more into the slats and more into the grantor retained annuity trusts and more into why you may want to put part of the family business into a charitable arrangement, and whether you would want to use what we call WANDRI percentage correction clauses or what we call King adjustment clauses on the promissory notes. So we can get to all that next week. I would rather right now get into something that we can intelligently handle in the next 8 minutes. And that is what kind of planning to do for the children or the other descendants. And usually it's pretty easy if you have a spouse with common descendants. It's going to go on the first death to a credit shelter trust and maybe a Q-tip trust that's going to benefit the surviving spouse. And then the question is, what do you do on the surviving spouse's death? Or what do you do on the first death? And for a lot of clients, the impulse and the decision, which is a valid decision, is I want to treat my children equally to the extent that I can. So I want to have a separate trust for each child. But, you know, I've got the business and I've got the real estate and I've got the investments, and child 1 and child 2 are in the business and they get along and everything's great. And honestly, the business wouldn't be what it was without them, because it's either so much better because of them or so much worse because of them. But it's one thing or the other, and usually the parent thinks it's better. So what am I going to do for child 3? You know, the business is worth 10 million and the other stuff is worth 20 million. So I can't leave child 3 out in the cold. Or actually, I'm sorry, the business is worth 40 million, the other stuff is worth 10 million. I can't leave child 3 out in the cold. What am I going to do? And the answer is you rebalance. So child 3 is going to get other stuff, and the business is going to go to child 1 or child 2. But a lot of times it's lopsided. So what happens is, let's say child 1 is really the dynamo. You want child 1 to get the business, but the business is 50% of the value. So child 1's trust takes the business and owes a promissory note to child 2's trust, and owes a promissory note to child 3's trust. And then if child 1 is aggressive and may take advantage of things, we might put the voting stock for the company in a control trust and let somebody neutral have that control trust. Child 1, you go keep working in the business, you prove yourself, and you make sure that these payments get made to child's 2 trust and child's 3 trust. Child 2 and child 3 are going to own the business real estate. The business is going to lease it from them. Maybe there will be an option to buy it after a period of time. The buy-sell agreement says that the lifetime CPA for the family is going to decide what the purchase price is going to be. And will everybody be happy? No, everybody will not necessarily be happy. There's a good chance that some child or the spouse of a child or the children of a child will be very jealous of child 1, or child 1 may fail and be very jealous of child 2 and child 3. But at least they are separate here. And by setting up the control trust before the parent dies, you don't have to worry about child 1 bullying the parent, and the value of the remaining shares are reduced. So that's the separate trust for each child with a buy-sell agreement. Now, you could put life insurance on the parent and have the child 1 irrevocable trust own the life insurance and use that to buy out child 2 and child 3. And you may want to put some life insurance on child 1, so if child 1 dies, there's value for child 2 and child 3 in case the company would otherwise crash and burn. The other alternative, which we do see and we will draft for when it happens, is, oh no, my kids need to work together, and I want them treated equally not only on the day I die, but until the death of the surviving child. So they are going to be put together in the pot trust. It has nothing to do with the marijuana they may smoke. This has always been called, since the 1950s, a pot trust. You put the inheritance in a single pot, and the children share the inheritance, share and share alike. Maybe it divides into separate equal trusts for the grandchildren, or for the great-grandchildren, or for the great-great-grandchildren, and that is the pot trust. Now, it's not unusual for a business to go into the pot trust. I do encourage my clients, if you want your kids to get along, they shouldn't know each other's deep, dark secrets. If you're in a pot trust, they're jealous of how much each of them get out. They know each other's problems. They get the annual accountings. Maybe put the business in a pot trust and divide up everything else. That might be a easier or more foolproof way to do it. And then I've even got language for you where one child's trust buys the other trust out. I don't know about you, but when you go to the form books and you find all these long forms, doesn't it feel better if you just write it yourself so you know it works? Or maybe use something a little bit less complicated so that the client can read it and understand it. So here, this family, with the assistance of their CPA, used a weighted average of EBITDA formula. So the CPA doesn't even have to do the valuation other than to run the math. There may be an argument over whether times have changed. When you do a formula clause, I like to have a times have changed clause. If there's a massive problem with the business right before the parent dies, maybe the EBITDA formula, the multiple of earnings formula doesn't work. Maybe it's just a rule of thumb. But anyway, I've also given you language here for a sibling-controlled business where the sibling, Slate Insurance Inc. So maybe it has to be a woman-owned business. There are a lot of those that do quite well. How are you going to take care of those male siblings? There needs to be a buyout. Is there going to be a non-compete? If you're going to get paid, are you going to agree not to compete? What happens if the business gets sold and there's a big windfall? Everybody needs to work in the business, but if you don't work, you get fired. Do your kids get to work in the business? All that stuff can be worked out. Okay. Camille says, gotta go. Can we see a recording? Yes, you can go to YouTube and this will be there very soon. We got to page 113. We're going to go back and do the estate tax planning next week. I believe it's next week. And let me just scroll back here and make sure I know, see if Brittany put the schedule here. Maybe she did. Usually we remember. Hope you're not getting dizzy. I should talk backwards when I rewind. And got a schedule. Oops, we don't. Okay, we'll be sending you a schedule. I think we go part next Saturday. Also, by the way, if you did not get our Thursday report, it went out Thursday. We were very proud of our 7 law students who worked for us over the summer. Thanks to all of you. And now let's open Estate View. So let me find my Google Chrome. There you are. Okay, so I go to my Google Chrome and I put in estateview.link, and up it comes. You then can go to large gift slat, and let's say that there is a 40%. By the way, if you're watching this on YouTube, you can go down to the controls and increase the intensity of the view to enhance what this looks like. So the exemptions dropping to half in 2026, estate tax rate 40%. By the way, I'll go to Pro Plus. So dropping down to half in 2026, no spouse right now, 40% estate tax rate, inflation 4%. Let's say the client is age 60, a youngster. I see their life expectancy is 23 years, but most people live longer than the standard life expectancy. So let's take this baby to age 100. Okay, and then you should always know, what are they saving now? Maybe this 60-year-old's going to save $500,000 a year till she retires in 10 years, and then she'll start spending $200,000 a year for 10 years beyond her pension and Social Security, and then after age 80, she'll spend only $100,000 a year, or maybe $150,000 a year. All right. So then she's in a $1.5 million home growing at 3.75% and has $25 million of investments growing at 8%. And she's paying income tax based upon 1.75% of the value of her portfolio every year. And she is interested in making a gift and seeing how that will affect her federal estate tax. So first, she would like to see a $1 million gift. She doesn't want to run out of assets. So I click on see results, and now things get fun. My inputs are on the left. Everything I just put in is all on the left. And my spreadsheet showing her situation is down here on the right. And by the way, I can export this into a spreadsheet by clicking Export to Excel. And this shows me that her core exemption is $6.8 million, And after the gift, it goes to 5,000,008. Her temporary exemption goes to 6,805,000, 7 million, and then 0. She lost it. Total exemption is going to go down to 6,003,000. And this new trust exists, and she's going to pay the income tax on the trust income. We call that the burn. So she's going to have estate tax savings from paying the trust, the income tax on the irrevocable trust income. She's going to have estate tax planning because the million's going to be out of her estate because of the growth. And how much is that savings? I go to the top. The top shows me $1 million gift. It shows me estate tax savings of 8,000,002. That's a nice thing. And from that 1 million, she saved 8,000,002. The estate tax is still 98 million. You think she should gift a little bit more? Oh, and by the way, you can show her without the gift, estate tax 106 million, with the gift, estate tax 98 million. Hallelujah. We saved quite a bit there. Okay, so then she says, okay, maybe I'll give 7 million. So I click duplicate here, and then I go down here and I click to 7 million. So now I have a new spreadsheet. It's called gift number 2. And I see now that there's going to be a bigger effect. The burn is really nice there. I mean, in year 8, her estate has gone down by $1.6 million because of the income tax. So the savings are significantly more. By the way, I can show more detail on this spreadsheet. I click on alter details, and then I can show the in trust value, the year 1 value, click close, so I can show more things. But what's neat here, I like, is I still haven't used any of my core allowance. I still am losing my whole temporary exemption. My savings per gift, 8,003,000, because I used just a tiny bit of the permanent exemption. But the total estate tax savings, $58 million. Not to sneeze at $58 million. And that's on a $7 million gift. And at age 100, she still has 140 million, so she's not going to run out of assets. So she's pretty happy. So now she says, what if I'll just give 1 more million? So gift number 3, I'll crank that gift up 1 more million. And what happens here that I think is pretty neat is now you've used a little over $1 million of your temporary exemption. So the estate tax savings on that million is 8,7 million instead of 8,3 million. So now she says, so that's 8 million, and now I've got her at 66 million estate tax savings, and at age 100 she'll still have 118 million. So now let's go for the gusto here. Duplicate that and say, what if you go to 13,610,000? See, it turns green. And at 13,610,000, the estate tax saving is 106 million. But look what happens. She ran out of assets at age 100. She's at negative 3 million. So let's see what that looks like. I go to timelines and charts, and gift number 1, big estate tax as she grows. There's her house, there's her investments. Gift number 2, smaller estate tax, but still a lot of estate tax. Gift number 3, more estate tax. Less estate tax. Gift number 4, much less estate tax, but she runs out right there, which she may not want to do. But what I can show her, you guessed it, I can show her gift number 5. Gift number 5, I can show her, look, a big thing that's happening here is the burn from the grantor trust. In fact, look at this. By age 39, her estate will be smaller by 173 million because of paying the income tax on the trust. Let's take a look at this. Go to gift number 5 and see she ran out of assets there, and it scares her. She may not want to do that. So what if I show her that if you toggle off grantor trust status in year 40 or year 39, then you won't run out of assets. So let's not worry so much. She says, that's good. How can I save more? Well, one thing we might do is make a larger gift. But she says, I don't want to pay gift tax. All right, well, instead of giving 13,610,000 of assets, why don't we take a little discount? Why don't we use an LLC and we'll give more? We'll put 15 million in a, we'll put, let's see what it looks like. We'll put 13 million in an LLC. We'll gift the 99% non-voting member interest, and we'll take a 30% discount, or let's take a 28% discount because it's non-voting. So we're really moving almost 13.6 million out of your estate, but we're going to call it a $9,800,000 gift. And it doesn't really save that much. It saves a tiny bit because we're saving her a little bit of her exemption. But what if we take a little bit of a risk and we really put $15 million in there? In fact, let's measure this. I like to measure things. So I'll click duplicate there. So here's gift number 5, and that's with a 13.6 million in the LLC, 7.8 million gift. We just did that in gift number 5. Gift number 6, now we're going to crank it up. So crank that up to $18 million gift. A little bit of a risk of gift tax, but really not a lot of risk of gift tax. In fact, we could crank it down there to 17.6 million. Small risk of gift tax. Explain that if you pay the gift tax, it even saves you a lot more, because if you pay the gift tax, the gift tax you paid is out of your estate. So now let's look at these two. So I'll go back to summaries. And with that 9.7 million gift, she's not going to run out of assets, but her estate tax saving is 106 because it zeroed out the estate tax on both of them. Okay, so she didn't need to even go that far, but we'll see what they look like here on the timeline. Gift number 5, she runs out there, but still a lot of estate tax if she dies earlier. Gift number 6, wow, much less estate tax just from taking that little discount. She runs out at age 86, but again, if we toggle off the grantor trust status, show her that she can toggle off grantor trust status at a particular year, then we toggle off grantor trust status earlier, then she's not going to run out of assets. So we'll just have to have a meeting in 21 years, in year 27, and we may have to start toggling off grantor trust status there. Now, there's some other things the calculator does for those of you who are still on or are asleep. One thing is we could show her that if she did a private annuity in a particular year, then she could sell some of her remaining assets to the trust in exchange for a private annuity in a particular given year, and that could delay the exhaustion of assets. Or she could use a self-canceling installment note. The other thing, just so you know, is she might be married. Maybe she'll say, should I get married and do a slat? So then you can click there, and then it's going to show what happens, for example, on the spreadsheet. Now it's going to show what gets into the bypass trust when she dies, what goes to the credit shelter trust when she dies, and what the surviving spouse's situation is going to be. The other things that Estate View does, just so I can show off because I'm so proud of it, is I can film a videotape, of course, showing her all this, and then I can click on General Explanation, and I can show her an explanation and a checklist and a PowerPoint, which can have all the information. Click on that, and then it creates the large gift explanation, and it should have created a PowerPoint. Let's see what happened to my PowerPoint presentation. There it is. So now I've got a PowerPoint. I click on the PowerPoint, and it's creating the PowerPoint. By the way, it works on Apple. It works on a Gmail. Let's see. There's my PowerPoint, and then my PowerPoint tells you what we did, what the situation was, what the client's name is, what happens before and after the large gift, what my assumptions were, what it looks like if they die each particular year. And so we like doing that. See there, go back. And then the other thing I can do is I can share this with the CPA, the other advisor, and with the client so they can watch the video I film. And then if they use the code 457825, I can paste this into an email, and then you'll be able, or whoever I send this to will have 14 days to use this calculator. Now, the client may say, well, how long am I actually going to live? Well, I don't know how long you're going to actually live, but I do have a life expectancy calculator, which will tell me that someone your age, 63, and by the way, how long will my spouse live? He's 70. Okay, well, I can tell you on average that the 63-year-old is going to live until age 26. I mean, will on average live 20.6 years. The 70-year-old's 15.4 years, and there's a 50% chance that at least one of you will make it to age 24.5. And then they say, well, you showed me a 7% rate of return. What is my likely range of rate of return? Okay, I'll go to the Monte Carlo calculator, and let's say that you have a 35% bond, 65% equity portfolio, and you're going to hold on to it for 20 years. And I can click here, and this shows me across the top that based upon 10,000 rolls of the dice, which it just rolled, and based upon the results from 1939 to present, the 50th percentile rate of return is 9.1%, but the lower 10% rate of return is 6%, and the worst 1% rate of return for these 10,000 rolls of the dice, 3.64%, the best 90th percentile rate of return, 12%, and the best 1% of the rolls of the dice showed a rate of return of 14.6%. So you gotta, and what did that do? Well, after 20 years, you're gonna have somewhere between 2 million on your $1 million investment portfolio or 14 million. If you're going to do the worst 1% or the best 1%, most probably 5.7 million, but a 10% chance of 3,000,002 or less, and a 10% chance of 9,000,007 or less. So that's the Monte Carlo calculator. And then they may say, well, but I've got, what am I going to do with this IRA? What's it going to be worth? Is it all going to go to taxes? Well, oh, I'm sorry, wrong calculator. Go to the RMD calculator. You're 68. You're going to go to year 100. Let's go to 101. 8% rate of return, 37% income tax, $5 million in your plan, inflation at 4.1%. Click on results. And here you're going to start taking your minimum distributions at age 74. And look at this. It just keeps going up, up, and up. It doesn't start coming down until, look at that, age 99. The RMD amount keeps coming up. Now, the value of the plan starts going down at age 88, or actually, let's see there, age 92. But actually, the RMD amount keeps going up until age 99, but nothing's going to charity. Would you want to see what would happen if you gave $100,000 a year to charity? Well, sure, I'd like to see that. Okay, well, let's go $105,000 a year. That's what the inflation-adjusted charity is. And you can either start this when you're 74 or earlier. Well, I'll just start it at 74 when I have to start taking minimum distributions. Okay, well, here's how much it goes to charity. And charity will get 14 million during your lifetime, and you'll save 2,500,000 in taxes. And in fact, the first year you'll save 50,000 in taxes. You'll have $298,000 left. Do you want to make the charitable contribution? Oh yeah, that'll be very nice. So we have a lot of different calculators, and a lot of you are still here. So I'll just show you one. Well, you may not have seen the letter writer, just so you have it, especially for you lawyers, but I think for you accountants, it's neat too. This just takes you through a letter to a married couple or a single individual and lets you select, do you want to talk about the importance of confidentiality and the attorney-client privilege? Do you want to talk about the CPA privilege? Do you want to talk about possible different types of conflicts of interest? Do you want to talk about joint representation? Do you want to make sure you mention the business purpose for your family LLC arrangement? And which of the business purposes do you want to talk about? Do you want to mention fraudulent transfer issues? Do you want to refer your client to one of these different types of professionals? Do you want to make sure you remember to confer with certain professionals? And then once you've clicked the boxes, or tell your secretary which boxes to click, it of course writes the letter. So this letter becomes a Word document that you can then edit. So this should save a lot of time. So there is the letter, the Word document you can edit. And then finally, I'll go to the married couple module. We have a single module and a married couple module. And by the way, the NEST module provides retirement planning to figure out how much they need to retire and how much they'll be able to spend on retirement and how much life insurance they'll need. Oh, the life insurance estimator. Oh, you might want some life insurance. Maybe not leave your family so destitute if you die. You're 56 years old. I think you need 3 million. Okay, here's what it may cost. Standard for 20-year term, 11,004 a year. If you're really, really healthy, 7,400 a year. If you want a lifetime pay of equal payments, maybe about 64,000 a year. you know, we don't sell life insurance and we don't want to sell life insurance, but at least this gives you an idea of what it might cost. So then I can go to married couples comprehensive. Do I want to show a credit shelter trust, a QPERT, a qualified personal residence trust? Do I want to show annual gifting? Would I like to show discounted annual gifting? Would I like to show a life insurance trust? Would I like to show a large gift this year? Would I like to show an installment sale? Would I like to show leaving enough to charity to zero it all out? Of course I do. So then I do all my entries here, or I can make it bigger. So, and do all my entries. You can see there's not that many things that you have to list, but there's plenty that you can if you want to. And then I simply say, okay, Bob and Mary, here you are. And by the way, if they say, you know, I see this number, but I just remembered that I think that we should use a growth rate a little higher. Okay, fine. I think I'll live a little longer. Okay, fine. All right. So if you die this year, a little problem. If we do our planning maneuvers and you die this year, no problem. But if you die in 35 years with no planning, your little $32 million estate will be a $71 million estate tax. And if you die in any of these years, along the way, the estate tax is pretty big. Of course, we could kill that first spouse off a little earlier or a little later. But if we do a credit shelter trust, we could save about 13 million in taxes if we do a credit shelter trust on the first death. And then if we do qualified personal residence trusts, we could save a lot more in taxes. In fact, if you pay rent to the qualified personal residence trust, we'd have over $14 million out of your estate from rent payments by the time you die. And those are the qualified personal residence trust is underused for most clients that we see. You can do some annual gifting and get more out of your estate. You could gift discounted LLC interests and get more out of your estate. By the way, when I click on each of these things, you see the input appear on the left. So you can, if the client says, yeah, I like that discounted gifting. What if I give for my son-in-laws too? Okay, well, we'll change from 6 donees to 8 donees. And what if I use a 30% discount? Okay, we'll go to 30%. Changes all the numbers instantly. Okay, how about a large gift? All right, let's look at a large gift. We were just talking about large gifts. How much are we going to gift? Maybe $1 million, maybe $2 million. As you gift it, you see the result. You see how much they're left with at each interval, and maybe that large gift is a good idea. And maybe we'll do a little bit of discounting with that large gift. But we've still got a little estate tax left after the large gift. How about an installment sale? Click on installment sale. That zeroes it out. We're going to talk about installment sale next week. I hope you'll join us because it's really, really powerful. But maybe they don't want to do an installment sale. And maybe they don't want to do as large of a gift. We crank that gift down. Oh, I'm sorry. Take out that installment sale. Maybe reduce the gift where they're going to have some taxes. So now, how about if you leave some assets to a charity or a charitable lead annuity trust? I'll click on CLAT, check on testamentary charity, and now instead of paying estate tax, $7.3 million goes to the charitable trust, which pays income to charity or payments to charity for 20 years, leaving another $3 million for the children later. And we have a separate calculator for charity. We have a separate calculator for installment sales. We have a separate calculator for the annual gifting that you saw. We have a separate calculator for QPERTs, but this is a really good shorthand way. So now this is what I want the client to do. This is what I suggest. I click on Generate Client Letter, select all scenarios, show timelines, click on Generate Client Letter, and Then now it's writing the letter. It even talks to you while it's writing the letter to keep you a little bit busy. It tells you about what it's writing. And when the letter's done, there's all these little squirrels in the internet, and they're all writing this letter. So then there is my letter. It'll also prepare the PowerPoints, but there's the letter, and I can enable editing. And then the letter is a Word document which you can customize. And if you change the plan, you can do another letter. You can redline the two letters if you want. There's all my inputs, and there's an explanation of each output, and there's all my outputs. So I'm pretty darn proud of this thing. I'm very proud of my son-in-law, David Archer, who got it started and designed the chassis. I'm very proud of Kevin Gray, our full-time programmer, who's been working with me now for about a year, and our sales team and all that stuff. If you would like, oh, I've got another polling question for you. Let me do this polling question. Okay, I'm gonna go to there, and this polling question, I'll launch it. Would you like to do a free workshop on how to use Estate View? And if you'd like to do a free workshop on how to use Estate View, we'd be delighted to have you. No charge. You will not get a free condominium unit. It's not a sales call. It's you and others will just simply get an instructional. Thank you so much, 91% of you. I'm very proud of that. So appreciate that very much. 41% of you voted. So that's about 20 of you. That's good. And then if you want to use it, if you want to do Estate View to pay for my bad habit, I recommend, and it's a 30-day free money back guarantee. I would recommend the $3.99 that does everything. I mean, sorry, the $4.99 that does everything. But if you attended this webinar and you buy it today, sorry, this sounds corny, but we know from experience that some people will buy it if I offer you a 10% discount. So 10% discount, go to estateview.link in your browser, put in 10 PERCENT, and get 10% off. If you're watching this on YouTube, send me an email and I'll tell you what the code of the day is for a 5% discount. Also, if you go to estateview.info, that's Estateview, ESTATEVIEW.info, in our website, you will see, and I'll show it to you here. Let me see if I can get my browser back. Where'd my browser go? I'm working on 5 screens here, so things get lost. But if you go to estateview.info, this is free, and you can scroll down and you see, thank you Blockmacher, Hesh, and Keebler for working on this with me. But towards thank you Blockmacher video. But then if you, here you've got a 1-minute video, 5-minute video, 30-minute video, 1-hour instructional video, so you don't have to go to our thing. You could put this on one screen and use it on the other, then get your money back within 30 days, or attend a workshop, and we'll be contacting you if you don't contact us, if you clicked yes on that. And then there's our pricing. And if you buy, and here's what each model has. But I would say get Pro Plus, and then within 30 days, let me know if you want to ratchet down, because then you'll know what you want. The Elite Pro is just the same software, but we help you a bunch. And then here, if you want to buy multiple, like we had an order last week for 22. So they're paying $324.96 for 22 people to be able to use it. So that's my sales spiel. Sorry to have to listen to it, but Marcia wants this to break even before I turn age 70, and I'm only age 65. I want to thank you again for attending this webinar. Like I said, next week we'll be back on talking more about the estate tax planning. Then we'll be doing other things relating to planning for businesses, including, let's go back to that table of contents, buy-sell agreements, how to separate business assets, the CREST, which you'll want to know a little bit about, and charitable planning for business. So we got a couple, 3 more days probably on this. Thanks again. Have a fantastic rest of your day. In the words of Steve Lineberg, I hope this helps you help others. That's what's most important. And thank you very much. Bye. Goodbye.